my name is Elisa. I'm an assistant professor at CUHK Faculty of Law. And today I'm super excited to bring you Jacob Singh, who is the ODR Director at eBRAM. eBRAM has been around since 2018, but they're really kind of becoming more and more popular. Only the last couple of years, there was a big event on the 3rd of May where there was a big conference about the actual implementation with a lot of participants and with a lot of demos. And I hear from Jacob, we're gonna have a first-hand experience of one of the demos today, which is super exciting because eBRAM and Jacob actually not just talk about AI, but they implement AI in practice. So 2 or 3 sentences about Jacob. I understand everybody has his CV on our event website. So Jacob is, as I said, ODR Director at eBRAM, and he has been a practicing lawyer and solicitor for over 7 years, specifically acting in the area, advising in the area of international arbitration, but also in technology. Okay, so how I want to do this, if that's okay with everyone. So Jacob, you would be speaking for roughly an hour. I assume there will be a lot of questions. So please send the questions to me directly, not to Jacob, because we do not want to distract him. We're gonna have a lot of time for Q&A, up to 30 minutes. So Jacob, whenever you're ready, I'm gonna mute myself just in case.
Thank you. Thank you so much, Dr. Mick, for the kind introduction. I'm just going to start sharing my screen. And I hope that works. Should work now. So yeah, I'm very, very honored to be speaking at this webinar for CUHK's Center of Legal Innovation and Digital Society. And I'm looking forward very much to sharing a comparative analysis of ODR and ODR-like dispute resolution mechanisms in the context of business and technology. Before I begin, I would like to start with a small disclaimer, I suppose. As Dr. Mick mentioned, I am the ODR Director from eBRAM, which is an arbitration and mediation institution established in 2018. That is also a law tech company, and which operates a number of platforms and services, amongst which is the ODR platform, of course, and which in turn is used to support our arbitration and mediation services. So the point of my disclaimer is to acknowledge this, and that during the webinar, I will inevitably be making a bit more reference to eBRAM's ODR platform, because that's just going to be the easiest reference for me to make when trying to dive into the topic. So having said that, it is the objective of this webinar to, number one, explore the range of ODR and ODR-like mechanisms by making reference to some other key solutions. And I will endeavor to do this, hopefully, by giving as fair of a view as possible. And number two, to understand the strengths and weaknesses of key ODR and ODR-like mechanisms. And three, and most importantly, I would say, to hopefully enable you as lawyers or business people at the end of this webinar to be in a better position to advise or choose the most appropriate dispute resolution method, depending on the nature of your or each particular case that you might encounter in the future. So we start first with what is ODR. ODR stands for Online Dispute Resolution. This seems like a pretty simple term to understand, but you might be surprised to know that when I speak with different people about online dispute resolution, the understanding of the term can actually vary quite a bit. So what then is online dispute resolution? Some people think that it means it's some sort of computerized or automated process for dispute resolution. That means that it's going to be faster and cheaper to resolve a dispute. That could indeed describe certain characteristics of certain types of online dispute resolution mechanisms. But describing it in this way does not actually help identify what is online dispute resolution. I mean, when we compare arbitration and mediation against litigation, arbitration and mediation or other ADR mechanisms could just as well be described in the same way. That is being a type of faster, cheaper dispute resolution method than litigation, for example. Some people think that online dispute resolution does not just mean that there are automated processes, but that there is a decision-making aspect within that. So how do you do that? Usually by using a specially designed algorithm or even by using artificial intelligence. There are times when people ask me, does online dispute resolution mean that judges, arbitrators, and mediators will be replaced by computers or artificial intelligence in the future? So that's the second type of variation of online dispute resolution, or the meaning of it. But as we'll soon see, there are certain types of novel dispute resolution mechanisms in the market that are aiming to achieve just this. But I would say that having algorithms or artificial intelligence for making decisions is not a prerequisite to being considered as online dispute resolution. Some other people say, oh, I know, online dispute resolution, we have been using it during the COVID pandemic, and we had a lot of virtual hearings held via Zoom or Teams or other video conferencing software. Surely that is doing dispute resolution online. Well, I'd say that it's still not quite the case. Conducting virtual hearings might be one aspect of online dispute resolution, but certainly online dispute resolution is not a synonym for holding virtual hearings. And I would say that online dispute resolution tends to cover more than virtual hearings. So does online dispute resolution just mean that it's some online version of ADR? In a way, yes, that's true, but also there are some features that distinguish ODR from being just an online version of ADR. After all, I don't think I would be wrong to say that most arbitrations, except during the hearing stage perhaps, are regularly done via emails between the lawyers. So in that sense, we have been doing online dispute resolution for a long time, but that doesn't quite match up with some of the other expectations of online dispute resolution that we've just discussed just now either. So perhaps another approach to identifying what is online dispute resolution is to take a more practical approach. It's no good to have a new type of dispute resolution mechanism that doesn't really quite work. After all, today we are about discovering the types of dispute resolution mechanisms that can actually be potentially used by your clients and by businesses. The approach we can take is to ask what we're looking for in online dispute resolution. What do we need it to do for us? What are the characteristics that it might have in order to be useful at all? I think that we can all agree that the best type of dispute resolution mechanism are those that have a strong legal foundation or legal basis. It's understandably a waste of a client or lawyer's time and energy to go through some dispute resolution methods if it ends up having little legal effect. People often ask me when I talk about online dispute resolution, is it something that's legally recognized? Is ODR legally recognized? And a related question to that is whether any result from the ODR process is enforceable at all. When you consider issues regarding enforceability, a natural next question is whether, apart from being enforceable domestically, can the result also be recognized and enforced in other jurisdictions? There are situations where your client has cross-border dealings, or the bulk of the assets of the counterparty which your client is claiming against is situated in a different jurisdiction. Ideally, an online dispute resolution process, being inherently online anyway, and seemingly, operates across borders, should generate results that are also enforceable across jurisdictions and borders. So next, you would expect that the mechanism underlying online dispute resolution should be capable of covering most types of disputes. So it has to have a wide scope of application. It's again not much use if you advise your client to opt for a particular type of dispute resolution mechanism, only to find later that it's actually inapplicable to your client's case, or it doesn't provide the type of remedy that your client is seeking. That's especially the case if the dispute hasn't arisen yet, but your client is required to pick its choice of dispute resolution mechanism for the dispute resolution clause in the contract with the counterparty. It's hard to anticipate the type of dispute that might arise later, assuming it arises at all. So a mechanism that can support a wider scope of application would likely be more preferred in such cases. And finally, the dispute resolution mechanism should be accessible in terms of both cost and in terms of usage. Accessible in terms of cost means that the costs of using the mechanism should at least be proportionate to the claims that will likely be made. If the cost of the mechanism is too high, it becomes uneconomical for the client to proceed with using the mechanism, and there will be little incentive to proceed with making any claim, even if the client's case has good merits. Whereas accessibility in terms of usage means that the dispute resolution mechanism has to be convenient in terms of usage. Being fast and efficient might be one aspect of accessibility in terms of usage, but the mechanism still has to be easy to access. Online dispute resolution mechanisms are supposed to ease greatly in this aspect because of its online nature, and the current level of penetration of internet services in the market worldwide means that anyone with internet access should be allowed and should be capable of communicating with their lawyers, build and argue their case without requiring frequent travel and physical transfer of documents, and without complicated technical skills in order to do that, without having to navigate through bundles of emails in order to properly run their case. So we've started to consider online dispute resolution mechanisms on a more practical level. But at this stage, I can understand it's still quite very much in the abstract. I have to admit, like, we're 15 minutes into this webinar now, and I still haven't quite actually given you a definition of online dispute resolution. So just wait a little bit for that. It will come. I, of course, have a view of what a useful online dispute resolution mechanism is for businesses and for the legal industry. But I did also say that I'd like to try to give a fair overview of ODR and ODR-like mechanisms that are available. So why don't we look at some example mechanisms first? So here on the screen, you can see that there are quite a few options. Of course, I'm not able to list out all the available ODR or ODR-like mechanisms in this webinar, as I won't have time to go through all of them. But what you see on the screen are some of the representative examples. To make this easier to discuss, I have sorted these mechanisms into 4 big groups. There are dispute resolution mechanisms that are tailored towards handling disputes between businesses and consumers, or otherwise B2C disputes. So that's the group where which is on the lower left corner of the slide. There are also dispute resolution mechanisms that do try to employ algorithmic techniques to take over the work of a judge or arbitrator, and that's at the top of the slide. On the opposite side, where human arbitrators are still retained for making determinations, there are traditional arbitration institutions utilizing certain ODR-like components, and there are arbitration-based ODR mechanisms as well. For these latter 2 groups, which are towards the right-hand side of the slide, the ODR mechanisms are still based fundamentally on arbitral processes, which would probably be familiar to most lawyers. So I'd like to take you quickly through each of these big groups so that you can get a sense of their characteristics. So first, I'm going to turn to consumer dispute resolution mechanism. So talk about the common characteristics. These types of mechanisms are usually operated by the online or e-commerce platform. And to name just a few, there's Amazon, eBay, Taobao, or for payment companies, there are credit card companies like Visa, MasterCard, or PayPal as well, with being not a credit card company, but a payment processor. While there are variations between the mechanism offered by each of these platforms, they generally follow the pattern where they first encourage the parties to negotiate a solution between themselves, failing which the platform operator would offer a sort of facilitation or conciliation-like process that is led by staff of the platform operator. If that fails, the platform operator takes on the role of both an investigator and arbiter and makes a decision for the outcome. Since consumer disputes tend to be low value but relatively high in volume, such ODR-like mechanisms that are capable of significantly lowering costs might be attractive to consumers and small businesses. The cost of these mechanisms is actually usually inclusive in the platform fees levied by the platform operator against the participating businesses, who may in turn transfer that cost to consumers through marking up their prices for the products or services. But this cost is not usually apparent to consumers, of course, and not even apparent to the participating businesses. So users may often treat these dispute resolution methods as practically free. For these mechanisms, the effectiveness of the dispute resolution mechanism mostly comes from the fact that these companies are able to withhold or reverse payments to ensure compliance with the outcome, because they are the middleman in these transactions. Since most relief sought in consumer disputes are usually monetary relief anyway, this can be quite useful. But where the dispute in question is not monetary in nature, unless there is a monetary equivalent that can be established, the mechanism might occasionally fall short of expectations. Another thing to note for these mechanisms is that they operate by way of the contractual terms of use, which practically means that they were entered into separately between the consumer and the platform operator, and the participating business and the platform operator, respectively. So two sets of relationships there. This means that while the dispute is between the consumer and the participating business because of the transaction, the resolution mechanism itself is actually not based on a direct agreement between the consumer and the participating business. Therefore, in using this type of mechanism, both parties have to rely heavily on the platform operator to be effective and efficient. Also, the outcome is very much a private mechanism. The parties' respective rights to seek further or other remedy is not, depending on circumstances, may still very much remain extant. So these types of mechanisms are not necessarily able to provide the finality sought by some parties. The next big group of mechanisms are dispute resolution mechanisms that incorporate algorithms or AI for the purposes of helping parties come to a resolution or to make a determination. So I'm going to give two examples of this. The first example I'd like to discuss is blind bidding. This type of mechanism is used by services like Smart Settle or Cyber Settle. For these types of mechanisms, the aim is to help the parties close the gap during settlement negotiations. So we can take a look at how this works here on the screen. We have a simple scenario here where the party on the left is willing to offer a settlement amount to the party on the right. And both parties inform the system independently of how much they're willing to offer and how much they're willing to accept, respectively. The key is that both parties don't get information on how much the other has actually proposed. That's secret. That's this little wall in between them, like a little secret there. So only the system knows both offers, but that's not shared between the parties. And if it happens that the offer meets the demand, then the settlement, the system would propose an immediate settlement, and that should be easy enough to understand. The case is similar when the offer made is larger than what is being demanded. The system still proposes an immediate settlement, and again, the reason for that is quite apparent. But on the other hand, if the offer is lower than the demanded amount, and remember, the parties don't know what the other side is demanding or offering, the system will first determine whether the offered amount and the demanded amount is close enough. If it's within its internally specified range, the system will try to make proposals to the parties to see if they will be willing to move slightly in the other party's direction. So from the perspective of each party, they only see the amount as suggested by the system with no distraction or emotional influence exerted. Now, in the case where the offered amount and the demanded amount are quite far off from each other, then the system simply informs the parties that they will need to make adjustment to their amounts. Again, there's no telling the other party what amount has been put forward. So blind bidding promotes a degree of fairness, in a sense, to the process, because it minimizes the chances of strategic bidding to the disadvantage of perhaps one side. More importantly, it might be sometimes more effective than when parties throw out numbers in front of each other while sitting across each other on a table. Because if the parties start off with amounts that are way off, one or even both of the parties might quickly lose interest in the settlement process, and they just get up and leave the table, seeing the other as being quite unreasonable, at least from their own perspective. So whereas in a blind bidding system, the amounts offered are invisible. So the parties may know that the offers proposed are far off, but they don't know by how much, and may therefore be more willing to give it a few more tries. Because after all, there is no harm to throw out a few more figures. The other side won't know about these figures unless the numbers are in close range. The online automation of this process, which is where the online aspect comes in, lowers the cost of hiring a middleman to conduct the blind bidding process. So it does help with the cost aspect a little bit. And the use of the computer system also makes it easier for the parties to accept the neutrality and fairness of the system. Whereas if you were hiring a live person to do the same, it might raise questions as to whether the person might be biased, or whether that person is connected with one of the parties and might surreptitiously pass on information to one side at the expense of the other side. Using an algorithm to process this type of mechanism also reduces errors made by the middleman during the transmission of the information. So that's algorithmic or AI dispute resolution. That's blind bidding. Now, the other type of algorithmic dispute resolution method that I'd like to quickly touch upon is it's more associated with Web 3.0 technologies, as the use of smart contracts, blockchains, dApps, being decentralized apps. The Clara system is an example of this. In this type of case, the disputing parties voluntarily submit their case to Claros, which is in the form of a decentralized application, a dApp, running on Ethereum. Ethereum being a type of blockchain system, if you're not familiar, from the blockchain hype cycle that we had a couple of years ago. The application recruits jurors to help decide the case. The jurors who take on the case first need to stake their own tokens for a chance to be selected. So there is some cost to it to begin with. The parties will also be required to pay the arbitration fees. So everyone has skin in the game, as you might put it. Both the staked tokens and the arbitration fees paid by the parties will eventually be redistributed to the jurors at the end of the case, depending on the outcome from the mechanism. So just to be clear here, the system selects not just one juror, but multiple jurors to decide the case. The selected jurors are required to review the evidence and vote on who is right and who is wrong. Of course, in such a system, the jurors are meant to be independent from one another, and they should not be colluding. The jurors who vote alongside the majority are called the coherent jurors, while the minority jurors are called incoherent jurors. The naming doesn't really matter, basically the majority and the minority. In this sort of system, the system assumes that most people will be making the right decision and will therefore be part of the majority or coherent jurors. To incentivize the jurors to make that right decision, the tokens staked by all the jurors at the beginning will be distributed only to the coherent or the majority jurors. So if you make a wrong decision, in the sense that you're in the minority, not necessarily that you're actually wrong, but if you're in the minority, then you don't get your tokens, and your stake tokens get redistributed to someone else. So for the parties themselves, the disputed amounts theoretically connected to the DApp or smart contract will automatically pay out to the proper party, depending on the outcome decided by the jurors. Whereas in the case we just saw before, where the arbitrator or decision maker was replaced by an algorithm, with Kleros, there are still people behind the decision-making process, but in keeping with its decentralization theme, Kleros instead distributes the decision-making functions to the jurors who are incentivized to decide on cases by promise of the cryptocurrency or crypto token rewards. But if you look at the system as a whole, it's still pretty algorithmic. It's a novel dispute resolution method, I would say, but it often requires a dispute involved to be connected to a smart contract or a DApp so that it can be auto-executed as soon as the jurors decide on the outcome. So more importantly, it assumes the jurors are not going to be engaging in mind games, like reverse psychology or trying to guess what the majority jurors will vote on. If anyone who's played Pictionary before, you would kind of get that sense where you're trying to guess what the other people are guessing sometimes. So there is that caveat there that they shouldn't be guessing what the other people are guessing on, and should rather be voting on what is objectively right, or at least in accordance with legal rights. So after all of this, gamifying the decision-making process could be quite dangerous when, especially when the incentives to make the decision do not necessarily align with the notions of justice and fairness. So that's one disadvantage of a Kleros-like system. Now I think I'd like to turn to a third group of ODR-like mechanisms, namely traditional arbitration institutions with ODR-like components. So let us start by quickly revisiting the institutional services that arbitration institutions usually provide. I'm aware that not everyone in the audience would probably have done arbitration. So just very quickly, an arbitration institution is generally responsible for case administration, for the publication of rules and procedures so that the parties don't have to draft or agree on their own rules for each individual arbitration case. So it doesn't become an ad hoc arbitration, or so to say. And the arbitration institutions will usually also have a vetted panel of arbitrators who can then be appointed in case the parties require assistance in identifying a suitable arbitrator, or in cases where the parties just aren't able to agree on an arbitrator and need a third party to help them with that. So various traditional arbitration institutions have also been providing additional services. So on the screen, you see 3 of the main services, but they to be honest, they have been providing additional services to support the arbitration process as well, especially during the COVID pandemic era. These include services that help with facilitating document storage and exchange, and supporting the use of video conferencing software. It can be said that some aspects of the arbitration process have become digitized. So usually these traditional arbitration institutions provide these capabilities through partnerships with external providers. In a certain case, for example, the use of video conferencing software, or the translation of documents, transcription, interpretation during hearing, all involve the engagement of third parties that need to first be agreed between the parties and then engaged by the parties themselves, even though there might be a referral from the arbitration institution. At the end of the day, it will be the party's responsibility to coordinate the various services, making sure the transcriber can access the documents on the document storage platform, or that the interpreter during the hearing can join the video conferencing system. That will be on the parties to make sure that happens, with some support from the institution. But generally, it is the party's responsibility to do all of that. The range of services provided in this group begin to approach online dispute resolution mechanisms, I would say. But I would also say that there is still a difference between traditional arbitration institutions providing these piecemeal ODR-like mechanisms and ODR institutions that themselves provide arbitration-based ODR mechanisms. So that's a lot of arbitration and ODR in that sentence, but I'm trying to make a distinction between traditional arbitration institutions that have parts that are ODR-like and institutions that are designed to be ODR to begin with. And that brings me to discuss the last group of dispute resolution mechanisms, which are arbitration-based ODR mechanisms. And eBRAM is one of those. There are a couple more in the world that you saw in the slide before. For ODR institutions that support arbitration-based ODR mechanisms, they don't just provide case administration services. They don't just publish rules and maintain the panels of arbitrators, but they also operate the ODR platform as a type of additional service from the institution. The ODR platforms, and here's kind of where I define what, at least to me, would be ODR. They differ from ODR-like components that traditional arbitration institutions use, in the sense that ODR platforms are end-to-end integrated enhancement of the dispute resolution process that are legally enforceable, that are for general disputes, that are legally that are done by way of application of online technology for enabling greater access options than traditional offline dispute resolution methods. So you kind of see that on the screen there. But what does this actually mean? So I want to pick out each of those blue chips you see on the screen there and explain it a little bit more. So first is end-to-end. End-to-end means that there is full coverage of the entire arbitration process. It's not just digitizing parts of the arbitration process, but from the commencement of the case to addressing case management needs, to having a centralized storage for documents, holding meetings, conferences, like procedural conferences, pre-hearing conferences, pre-hearing meetings, and the merits hearings themselves, or quantum hearings, whatever hearings that you may have, with an integrated video conferencing system. And as part of that, you would also have machine transcription included with the video conferencing system. So that allows for, on top of that, machine translation of the machine transcription, and also machine translation of documents generally stored on the document storage and exchange system. So That process goes on until the issuance of the award or settlement of the case. And so the entire process is meant to be covered under one platform. So here on the screen, I've listed out from head to toe what I think are common elements that an ODR platform would have. That is combined and brought to life by the institutional services. So it's a combination of there being a platform that people can use and also the services that are provided to support the usage of that platform. And that, along with the administrative fees, form part of the entire ODR platform. And the good thing about all of this is, as I mentioned, the payment of the administrative fees already includes the usage of the ODR platform. So in the case where you have a traditional arbitration institution, that's done separately. You have to go and engage service providers separately, pay separately. Now it's all under one administrative fee. And I think that's also one important point for simplifying the process and using ODR. So ODR is about technology. It's as much about technology as it is about making the process itself efficient as well. And as part of that, the integration of the ODR services with the institutional services also means that parties don't have to separately arrange for the services. So not only just the payment, but the hassle of the logistics of arranging the services with all the third parties. The agreement to use the institutional rules automatically is an agreement to utilize the ODR platform. So what I mean is the agreement to use the ODR institutional rules automatically is an agreement to utilize the ODR platform if it suits the needs of the parties. And that saves lawyers a lot of administrative effort and the clients a lot of cost in managing these ancillary services. So for example, at eBRAM, we've got 3 sets of rules, namely the eBRAM arbitration rules, mediation rules, and APEC rules, and these entitle the parties to utilize the ODR platform where it assists them. And it also has a couple of implications as well for using these rules. So I've talked about the integration of the rules with the ODR platform, but just having the ODR platform without the legal framework to support it is not particularly useful. So through these rules and through the institutional services, there are a couple more things, including, let me jump to that slide first. Let's skip one slide. There we go. The outcome of the ODR process is going to be an arbitral award that is recognized and enforceable in Hong Kong and in other jurisdictions, as would be the case with arbitral awards issued by traditional institutions. And since the underlying dispute resolution mechanism is arbitration, any dispute can be submitted to arbitration through ODR as long as the matter is arbitrable according to existing law, and that the parties can opt into the dispute resolution mechanism prior to the dispute arising and simply by inserting the appropriate dispute resolution clause into their contract during contract negotiation. Actually, let me go to the previous slide instead, because in relation to that last point I just talked about, eBRAM, for example, publishes its model clauses, which can be copied into contracts as the dispute resolution clause. Again, it's part of the entire integrated process. And as mentioned earlier, the inclusion of this clause will entitle the parties to use the eBRAM rules plus the platform itself. Now, specifically on the enforceability in eBRAM's case, because since that's a very important question in relation to the dispute resolution mechanisms that we're talking about, we want to make sure that it's enforceable. We talked about this near the beginning of this webinar. Because the ODR platform is integrated with a recognized institution, which is eBRAM in this case, users of the ODR mechanism can also benefit from higher levels of support, especially with respect to Hong Kong-seated arbitrations that are also administered by eBRAM. Specifically, I'm referring to the arrangement concerning mutual assistance in court-ordered interim measures in aid of arbitral proceedings, which provides an easier route to making applications to mainland courts if interim measures are sought. And the other thing as a recognized institution that eBRAM can do is to take advantage of the arrangement concerning mutual enforcement of arbitral awards, which allows awards rendered with the arbitral seat in Hong Kong to be enforced against assets and or entities based in mainland China. Now, what I haven't included on this slide is also, of course, the New York Convention. So anyone familiar with the arbitration process will know that Hong Kong, through China, is one of the contracting parties to the New York Convention. The New York Convention being an international treaty that allows awards, arbitral awards, to be enforced in other signatory member states or jurisdictions, an easier process to do that and enforce those awards as if it was like a court judgment from that jurisdiction. So again, that's where the cross-border enforceability comes in for ODR process. It's also why we make the ODR platform arbitration-based, because of those legal advantages. So that's LegalTech for you, marrying technology and the law. So the final point I'd like to make in relation to arbitration-based ODR mechanisms is at the end of the day, it's applying online technology to provide users with greater access options. And again, remember, we talked about accessibility in the beginning. And by being online, people have a choice of using online. We're not forcing them to use online if they don't want to, but there is a large advantage to having that there and to using the system. And to do that, I'd like to illustrate this point, I'd like to show you the eBRAM ODR platform. So I'm going to try to switch to the ODR platform. I hope you can see it on screen. And that's okay. So another small disclaimer, this is not the actual production version of our ODR platform right now. Our actual version looks like this right now, but this is a version that's imminently going to be released. So this is actually the first time we're publicly showing this, and so I'm very happy to be doing this. It's like a premiere. So this is a slightly updated version that we'll be releasing soon. Hopefully, it has more updates, more features, and why don't I just take you through the system? So you can see right now that we have a case list, and this is where you're going to start off when you join the system, when you create an account and log in. In the case list, now when you first join, of course, you don't have any cases. So first you have a submit new case button, which takes you to a guided process of which rules that you want to use or which process you want to use. And we try to make this into a little a nice flow so that each step of the way, whether you're the lawyer or the client itself using this platform, you know what's going to come next and what you need to do. So for example, if you want to go with an ad hoc arbitration, then you can tick this box and it will tell you what the next instructions are. But if you choose to use eBRAM arbitration rules, which includes the use of the ODR platform, then you can click submit and it will bring you to a notice of arbitration. And traditionally, parties are required to submit this document without any templates, right? It will be up to the lawyer using their own precedents, or if they don't have their own precedents, they just look at the rules and try to figure out how to draft a notice of arbitration. In order to make this process simpler for both lawyers and users, we've made this into a form where you can just fill it in as with any other web online form. So it's easy to know what things you need. We've made it into one page in this new version, so you can quickly scroll down, gather all the information you need. The form is auto-saved, so you can start the process, come back later and finish the filling in the form. And once you do that, you can just submit it, sign it, and we have an e-signature function for that. You can electronically sign it, and then that notice of arbitration comes to our case managers will review the document, see that everything is order, and also help make contact with the respondent side. So that's how you do the case commencement on an ODR platform. It's more tangible than how it's traditionally done, where you are supposed to draft up a notice of arbitration somehow and send it somewhere, presumably the institution, but you have to figure out what the email address is and all of that. So here it's all done on the platform. And once you have a case in, it will appear on the case list. And now in this new version, we've combined all the cases, no matter whether you're doing arbitration or mediation or using our APEC rules, because we've got 3 sets of rules, and the APEC rules is a special version where it's where the rules are simplified and the procedure contains both negotiation, mediation, and arbitration in one go. So you can see, like, for example, here we've got sample cases. Some you've got APEC cases here, you've got mediation cases here, you've got arbitration cases here. So if you're a lawyer, or if you're an arbitrator, or even if you're a user, right, you can see exactly what role you're in which case type, right? So especially for lawyers, right, you may be handling multiple cases concurrently, and you need to keep track of that. How do you used to keep track of that using your own binders, but it's hard to know. It is no like clear list for you to know what cases are ongoing. Here, if you do cases on eBRAM, you can very quickly see, oh, I am in this arbitration, and in this arbitration, I'm actually the sole arbitrator. Oh, in that arbitration, I'm actually counsel for that case. So there's a clear list here. So let's just pick arbitration 1 as the example case. Now you can then go and click on the general information. You can see the basic information, the parties involved. You get your addresses, all the telephone numbers, all the contact details, who's the arbitrator. I'm in the arbitrator account, by the way. Currently, I'm logged in as an arbitrator just so that I can demonstrate most of the features. But this interface is similar for different users, except that they will have different functions depending on the role they're in. And again, that's automatic by the system. So here you get to see information about what's been uploaded recently, what's the next event. And you can see more case information here just to remind yourself if you need to, and also see the financial aspect of the case. So instead of having to email the institution all the time, and you have to do that within business hours, this is 24/7. You can log in anytime and see how much you've paid in terms of registration fees, how much you've advanced to the institution for the purposes of later paying off the arbitrator, etc. You also have functions in relation to procedural timetables. So here you can create a procedural timetable. Now, procedural timetables usually come along with procedural order number 1 in an arbitration, and parties traditionally do that by sending each other word drafts, right? I say, I should have 14 days for filing this document, and you say I need 28 days, and that one says no, you don't need it. You come back and forth, and then you send it to the tribunal. Tribunal says, why are you guys taking so long? Why don't you make it shorter? And then there's yet another draft. Now on the platform here, because it's live, you can actually set up a meeting and do this on the go. Like, you can have the procedural conference directly and add events, discuss immediately, add it. So everyone just shortens that back and forth time and just do it directly on the system, and you already have the procedural timetable here. And not only that, then you can also view it on a calendar view as well, where you can see the events. Now, currently we don't have a lot of events here, so there's nothing to see. I think this is June. Let's see if there's anything in June. Because probably these events are 2023. Okay, so I need to go back. This example was back in June 2023. So you see some events here, right? So those two functions are connected. Next, you also have the ability to share and exchange files, because documents are almost the heart of legal cases. Everything's based on documents. and there's a need to share documents, large amounts of documents. And in the past, how it's done is you either send it through email, or you have to set up a special FTP link, upload it to a certain server, send the link to the other side, ask the other side to download, and that's a bit of a hassle. So here, you can do the document exchange directly on the platform itself, and this can also form your arbitration record. So the parties agree that this is actually the arbitration record. You upload your evidence here, you upload your submissions here, and that just makes everything easier. And on top of that, you can also do translation of the document. So currently we support translation between 15 different languages. I'm not going to demonstrate it here today for this particular document translation because it takes a little bit of time. It doesn't take long, like 30 seconds, but I don't want everyone to wait here, waiting for that translation to be done. But feel free to contact us if you want to see more of that. But the point is that it's, again, an example of integration of machine translation, AI technologies into this. There's an ability to do e-signing as well. So in the case of a settlement, or if you're in a mediation, you want to sign the settlement agreement, you can do that there. For example, here I have a mock settlement agreement. If you have one side who wants to sign it, you can go ahead and click it. You can sign on the computer itself, or you can even use a QR code. I'm not going to display it for too long, so in case someone scans that. because you can actually scan that, and your signature will appear on the PC. But I don't know, I don't want how many viewers do we have today? I'm not sure, maybe over 100. I don't want 100 people trying to sign. It will probably overwhelm the system a little bit. But the point is, you can sign here, and it will appear on the document itself, and the other side can see that signature and also sign on their using their user account. So I'm going to close this and go back to the platform. And one final thing I'd like to show you is the video conferencing system. So we skipped ahead just now, right, when we talked about the documents, or we talked about when you're settling. But before that, of course, in the arbitration process, a large part of it is that you're going to have your procedural conferences, you're going to have pre-hearing meetings, you're going to have the merits hearing, cross-examination, all done. Now, you have a choice of doing it online. You have a choice of doing it physical. We support both types. You can do it hybrid. And hybrid is actually now, after COVID, is we see, at least as far as we observe in the cases that we've done, that seems to be the most popular option, because people do want to see and meet people in person. But sometimes there are cases where experts or witnesses aren't able to attend physically, or one party is not in Hong Kong, and it's not economical for them to travel here. Then they would utilize a hybrid situation. We've done procedural conferences where it was fully virtual, fully online, because it was not worth flying someone in just for an hour's worth of procedural conferencing. And again, along with that, there's also the transcription ability, which I'm going to show you now. So let me turn on the video conferencing. For example, I'm joining the conference.
You are currently the only person in this conference.
Now, a caveat here, because I'm appearing on screen on Zoom, I can't also appear on our VC system. So bear with me that it's blank screen for the video, but I can show you in terms of the transcription. So here we have the transcription that I've already turned on just now. And you can see as I speak, it's actually showing the transcription live. I'll try to increase the size of that so you can see. It's a little bit too large now. So this is useful, for example, in a procedural conference where you do want to have transcription capabilities, but it's far too expensive to be hiring a court reporter or not a court reporter, but a court transcriber in order to do this. It's too much of a hassle to arrange all of that for just an hour. Or even in like a hearing, sometimes you want to cross-examine someone, and you also want to have the ability to see this in another language. So there's a translation capability here, machine translation on top of the machine transcription. And you see the Chinese appearing right at the end of the sentence there in the parentheses. So you can have the ability to conduct hearings in a manner that you weren't able to before, where you had to have an interpreter doing simultaneous or consecutive interpretation. Now you have a form of simultaneous interpretation directly on the record. You don't have to have two transcribers, one transcribing English and one transcribing Chinese. You can just have the machine, the AI, do it for you directly on the system. So here we've designed the system to be as easier to use as Zoom, whereas Zoom, there's a 14-minute limit. Here we don't have that limit. As long as you're part of the case, you can continue to use it how many times, as long as that case is on, and you can use this transcription as much as you want as well. So that's all part of the one administrative fee, and we try to package everything under one house, under one roof. So it's a one-stop solution for everyone. And that's, I think, one of the key characteristics of being an ODR institution or ODR platform. So hopefully you enjoyed that little demo there. So I think I'm just going to go back to these slides a little bit. I want to see. Yes, so I just showed you the machine transcription. It's in real time, no breaks required. You don't, whereas there's a human transcriber that the person will get tired, you need to allocate breaks for them. It's on demand 24/7, all weather. No need for additional setup. You just turn on the video conferencing, you can use it. And as I've shown you before, it's integrated with the real-time machine translation, and it's just more cost efficient, especially for shorter hearings of shorter calls. And that it's utilizing artificial intelligence techniques, which which are made up of the natural language processing and the machine learning. So I'd like to wrap up today's presentation with a little bit of a comparison table here of the 4 big groups that we've looked at so far. You see at the top, there are columns for each of 4 big groups, and I'll go through the rows now. So in terms of the legal foundation, remember we talked about what we need in an ODR platform. You need a legal basis. You need a legal foundation. Or that's at least what a lot of lawyers or clients are seeking for. They don't want a dispute resolution mechanism that turns out to not have a very strong legal basis. So for consumer dispute resolution methods, the connection with the law there is that it's just based on the parties' respective agreement, and especially the agreement with the platform provider, not necessarily the other party, actually. And there's no special connection with the judiciary there. If it doesn't work out, all your legal rights are still there. You can still go to court. For an algorithmic dispute resolution mechanism, it's again based on consensus parties. The special thing there is it's decentralized. It's meant to cut out the judiciary. It's meant to cut out judges and arbitrators. So the legal connection there is less. And for traditional arbitration institutions and arbitration-based ODR mechanisms, because they work under the existing arbitration framework of the seat of the arbitration, and it's based on the consensus of parties, it's backed by the supervisory courts. So that creates a stronger legal foundation for the latter 2 types of mechanisms. Enforceability. The sense of enforceability is a little bit different for the first 2 types. First 2 big groups. For the consumer dispute resolution method, enforceable means it's enforceable to the extent that the funds are already held by the e-commerce and payment platform, and they're willing to refund in a sense. But there's no actual recognition process. The outcome isn't recognized by the courts. For example, for algorithmic dispute resolution methods, enforceability probably comes by way of the smart contract kind of executing itself, but it's not the kind of enforceability that we talk about in law. Whereas for, again, the latter 2 groups where it's arbitration-based, there's cross-border enforceability through an EU convention, there's domestic enforceability through local courts, and it is within the arbitration framework. There's the arbitration ordinance in Hong Kong, and that's under the legal framework in a lot of jurisdictions. In terms of scope of application, I would say that consumer dispute resolution methods are relatively narrow in the sense that they're only in relation to transactions that are done on an e-commerce or payment platform. Because once it gets outside of that, the payment operator doesn't have jurisdiction per se, even if that's a right term for that. So the scope of application is quite narrow. For algorithmic dispute resolution methods, theoretically, they're generally applicable, but it does require the implementation of smart contracts and dApps. And I think in terms of smart contracts, there's a limitation to what can be covered. You may have the automation of payment out. Like if you have an outcome, if Alice is right or if Bob is right, then payment goes to Alice or goes to Bob. That can be done by a smart contract. But if you're talking about quality, whether someone has tried their best, best endeavors, that's going to be a little bit more complicated. For arbitration-based systems, whether it's a traditional arbitration, institutional arbitration-based ODR mechanism, most types of disputes are arbitrable to the extent they are covered by the language in the arbitration clause, and they're not something that's by law not arbitrable, which is generally quite limited. Cost has to be, it has to be affordable. For the consumer, that's a big win for them because there's usually no apparent extra cost. It's already included in the fees that they've been paying beforehand. For algorithmic dispute resolution methods I talked about before, some of them require payment of tokens using cryptocurrency. It's relatively low cost, but as I remark in the usage accessibility cell at the bottom, it does require the use of tokens and cryptocurrencies, which not everyone has. So there's a little bit of low usage accessibility, I would say. Arbitration tends to be a bit more costly. Now, we've always learned in law school that arbitration is cheaper than litigation. Now, in practice, I think that's sometimes true. Sometimes it can still be quite expensive. So there is room for that to come down. And I think for traditional arbitration, that amount can still be quite high especially for smaller users, like smaller quantum cases. So using ODR, by way of using ODR, the hope is that some of the technology can help reduce some of the cost, and that means, and the rules and administrative fees are also lower, so that brings the advantages of arbitration to users who used to not be able to use arbitration because of cost barriers. Now they can because of ODR platform helping to reduce some of the costs in terms of engaging third-party translators, transcribers, etc. And finally, in terms of usage accessibility, consumer dispute resolution methods are dictated by the terms of the e-commerce and payment platform. Algorithmic dispute resolution methods, I've talked about that, requires the use of tokens and cryptocurrencies, kind of. And for the traditional arbitration institution, the procedures can be complicated for those who are unfamiliar, who haven't done an arbitration before. You may not realize that you need to do a notice of arbitration to start the case. And so that's where the ODR comes in, like I demonstrated before. There's a guided process through that platform, so that even if you're not that familiar with the arbitration platform, step by step, you can just follow what's online. Again, your use of technology is part of the rules. You don't need separate agreement for that. Requires no separate engagement of service providers for a lot of the common or key service that you need to use. So hopefully this chart and what I've talked about in today's webinar gives you an overview of the different types of mechanisms that will be available to you as a lawyer and to your clients as well, so that when in the future you need to select the dispute resolution mechanism, you can examine the specific circumstances of your case and find out which dispute resolution method best fits your case and helps resolve your issues the quickest and most efficiently. So thank you very much. I'm going to pass back on to Eliza. And I would just add one more tiny thing at the end is that, if you have any questions about at least the ODR platform that's hosted by eBRAM, feel free to contact us. There's our email there and our telephone, and also you can also visit us at our office as well. Thank you.
Wow. Jacob, thank you. Catch your breath. This was really, really cool. I remember when I was teaching ODR for the first time, I didn't quite get the big attraction, but I think you really made the most important point using the word integration. It's really, you have one place, there's no stupid endless exchange of emails. There's a call, there's a sticky note, there's a website, there is a link, and it's just one big mess. You just go to one place and everything is basically centralized, which is a beautiful thing. Okay, I have quite a bit of questions, and there's some questions from the audience, but the main question from the audience is they want the slides. So everybody wants the slides. I want the slides. So maybe first thing is, please remember, everyone, we are recording this event, so it is very easily accessible from our faculty website. I can put the link in the chat. Give us 1 or 2 days. It will not be available today, but probably early. What day is the day? Tuesday, probably Friday or Monday next week. So you're going to have the slides and you're going to have Jacob. So with live explanation, it doesn't get any better. But I have a couple of questions. Like one of them is a little bit technical. Was eBRAM? Because I saw a big jump how eBRAM went from, it was pretty embryonic just a couple of years ago. And now the system and the website is just pretty impressive. And it's, as you said, fully integrated. You have so many different things in one system. I mean, we could spend half a day just discussing just the translation and transcription alone. But okay, was the system developed in Hong Kong? Is it all, and more importantly, when you use the system, does the data stay in Hong Kong?
Yes. So I'll answer the data point first, because probably people are very, concerned about that. As a Hong Kong-based institution, our data is stored in Hong Kong. We use data centers. We've got 2 data centers for redundancy, in fact. And of course, we don't build the data center. We do utilize data centers that are provided by technology providers, but they are based in Hong Kong. I believe one of them is in Science Park, and the other one is Cheung Kwan O somewhere. And in terms of the development, a lot of the interface and integration is done by us. Now, we have utilized certain technologies that are available and built by others, and we can't obviously reinvent the wheel on every single point, and it would be ridiculous to do that. But the integration, the website, the interface that you see is done in-house. It's not just done in Hong Kong, but in this office. So yes, we actually the majority of the employees at eBRAM are actually IT developers.
Okay,
because we're more IT people than
it's really
here.
great. It's really great. I mean, I see so much progress because the initial system was much simpler and less sophisticated. Which brings me to the next question. Hang on, I'm just going to look at the chat. Okay, most of the people just want the slide. Okay, we have the slides. Would you mind if we share the slides, or if we keep the slides? Are we allowed to post them, to send them to people, or should people contact you directly for the slides?
Oh, I'll share the slides with Scarlett.
Awesome, thank you. But okay, so
I need to remove the animation somehow, so and then make it a fixed
that
slide,
would
so
that's the thing. Okay, so 2 questions. First question, okay. Why are more people not using ODR and eBRAM? Because I know that quite a few people still seem to have this mental barrier, which I really don't know where it comes from. So this is like, why is it not more popular? Because there's so much effort being put, not just in Hong Kong, but in China or in Southeast Asia, in Japan. In Europe, it's a different story, but everybody's trying to make it more, so many people are trying to make it more popular and more mainstream. First question. The second question is, what do you think? What are the main technical/technological challenges to making ODR even better?
Right. Okay. I'll answer the first one first. The first question is a really, really good question. And it's a question I ask myself every day in this role. Why isn't everyone already using this? Now, I mean, partially it's because obviously for at least for eBRAM, at least in Hong Kong, right? In Hong Kong, we're the only one that's really providing this ODR service. We launched the first version of this platform, kind of officially in February last year. So it's not a long time. It's a year or so now, and starting to get more popular. Now, it's been taking a bit of time, and that's, partially I go out to events like this to tell people about it. We had the ODR conference, as you mentioned, hopefully to get people to first even hear about us. I think a year ago, a lot of people didn't understand what eBRAM was, or they haven't even heard of eBRAM, or if they have heard of eBRAM, they weren't sure what it was about. And I hope now, and like after this webinar especially, that you now know that we do ODR. It's not the only LegalTech product that we do, but today the focus has been on ODR, and it's one of the key products and services that we provide. And in terms of usage in Hong Kong, from our perspective, we are getting more cases that are considering using us. We've got real cases, from parties which are around the world, not just Hong Kong domestically, but international cases as well, starting to know about us and actually try us out and use it and have good feedback on us, find that we're good to use, and they've actually come back a second time and third time to use us. So we're slowly getting there, but it also still takes a bit more awareness raising, I think, of the availability of this and what it actually means. Because the fact that, as you said, you may have heard of ODR before, but people aren't really convinced in the beginning, because isn't that just doing it online? Aren't we doing it online anyway? Right? We've been using email all the time. It's online. So what's so special about ODR? And you hit it on head very well. It's about the integration. It's about having just one place, all done, services and all, like services and technology, all done here. So you don't have to figure that all the logistics yourself. And that's one big part of doing ODR, I think. And another thing is that people sometimes are scared of change. Some people are enthusiastic about change. You and I are probably enthusiastic about change. Some people are less, and understandably so, because the legal profession tends to be a very risk-averse profession. Being a lawyer before, I know we talk about risk all the time. When we write advice, we want to make sure that we give advice, but not too much, not too little. And again, with recommending this, obviously we're not the only institution in Hong Kong. Hong Kong has for the longest time only had one institution, HKIAC, and they're really great institution. They've got lots of cases and they're really professional. But the thing is, there is a mentality that, okay, that's the one we trust and that's the only one we put into our contracts, and really haven't considered changing dispute resolution clauses to perhaps consider using online dispute resolution. So it will take time for people to put our clause into their contracts as dispute resolution, as a chosen dispute resolution method, and for those contracts to, in case a dispute does arise, it'll take a bit of time. So meanwhile, we're trying to still make this more aware to people, so that they know that it's an option, that it's not a risky option, that it's a legitimate option, and it's something that they can use. And hopefully today, I've demonstrated some of that, so that you have a very tangible sense of what ODR actually is.
Okay, the second question was about the technological challenges. Is there anything, look, to me, it already looks fantastic. I wouldn't change anything. I mean, you can always fiddle with the user experience to make it even smoother and prettier and easier. but the tech seems to be there. I'm just going to make a crazy assumption. I really assume that you do not want to you don't want to use AI to actually arbitrate and mediate. It's still going to be people. But apart from that, are you working on any additional technological enhancements? Are there any technical bottlenecks that you are dealing with?
So I'll address the assumption first. Assumption is absolutely correct. As long as I'm here, I think my view is still that our job as an institution is to link the parties to the arbitrators, and we think human arbitrators are still going to be the ones deciding the case. My view, having looked at the artificial intelligence, as great as it is now, it's not yet at the level where it can fully decide a case. I would say, and I think there are AI experts out there that share that view. Now, of course, you would hear different views. Some people think that they can. I'm of the camp that it doesn't, because I've tried using AI. I'm always trying like new technology, and I think that the current AI, especially the generative AI flavor of AI, is great for helping perhaps lawyers draft first drafts or something like that. But in terms of determining cases, making decisions, not really. Even for first drafts, you need a lot of supervision, I would say. It's a first draft, but you would have to put as much supervision as you would when you're reviewing work from a trainee, for example. So AI, I think for us, our current view is that we'll still have human arbitrators, and it's our job to link users up to arbitrators. Now, bottlenecks or applications of technology. I think the technology for ODR is relatively mature, actually. It's just in terms of application. How have we applied existing technology? And the key for us in terms of our continuous improvement is to apply technology in a way that's easy to use for people. And I wouldn't say that our system is perfect. I would be lying if I said that, but it's definitely at a usable state, and there are still corners to polish, all of that to make document exchange even easier, to have different workspaces. I can see like there are different aspects and features that we can add in, and it's going back to the integration point, integrating even more things so that it's even more centralized in one spot, so you don't have to go out to other figure out what other services you need to supplement the process. So there is definitely still a lot of room for us to continue to improve this, but that doesn't mean that it's not usable now. I think at this point it's already quite helpful for parties.
No, this is why I asked, because to me it looks and feels really good. And I saw the longer demo on the 3rd of May, and it was pretty cool. People in the audience were like gasping. It was really crazy. But okay, I have more questions. Okay, because I was looking at the eBRAM website, etc. And from what I understand, from what you said, it is basically eBRAM is for everyone. So technically, it could be a party from the EU, from Spain, from France, from Germany. But okay, if one of the parties is from abroad, I mean from the EU, then there would be a transfer of data outside of the jurisdiction into Hong Kong. Is that correct? That's the question.
Yes, that is true. But I think Hong Kong is a relatively safe jurisdiction. It is a well-known jurisdiction for its law and its data protection capabilities. For our system, in terms of data security designs, we adhere to 3 different sets of rules. So the strictest one actually being GDPR from the EU. So we adhere to that. We also adhere to the equivalent or PPO in Hong Kong, and also the PIPL in mainland China. So all 3, we comply with them. So at least in terms of data storage, it complies with the requirements. Now it will be a kind of transfer of data there, but I think in most cases, because at least the ones we are handling, the cases are seated in Hong Kong, so that helps mitigate that part. Now, in the future, and that goes back to your question about improvement, when we get enough throughput through the system, it's entirely possible for us to have data centers in other places. It's just a matter of economies of scale at this point. Because we're non-profit, we're non-governmental organization, there is a limitation in terms of the resources we can put in. So we can't have data centers in every single jurisdiction just yet. But when the day comes when there are more users, especially if it's from elsewhere, and we have cases from elsewhere, and they haven't raised issues about data transfer so far. But if that's a concern, please do continue to tell this to us so that we can also tell our stakeholders that this is a demand, and we can set up data centers and basically have our systems on those servers as well. So technically, it's definitely possible. It's just economically, we're currently limited to Hong Kong.
I just had this impression, but look, I'm not an expert in privacy and data protection. I mean, the PDPO is pretty strict. I mean, it is based on the GDPR. I think we are as safe as it gets in Asia. And if you're following the PIPL, the GDPR, the PDPO, then I mean, it doesn't get any better. Let's put it this way, if that's correct. Okay, so. One last question, because we're running out of time. I still have to make an announcement. I heard a rumor that there might be an app. Because, everybody loves apps.
So I don't know where you heard that.
I don't know.
You need to let me know.
I think there should be an app because we all love apps. Nobody likes sitting at the desktop.
I'm not sure if I'm at liberty to confirm or deny that at this point. What I can say is before we have the app version, our system is browser based at this point, so any mobile browser can still use the system. We've stuck to responsive design, which is a technical term meaning that the design of the website will fit different screen sizes. So it will fit on a mobile phone. We'll have the menu buttons all rearranged so that it's good for mobile phone usage. Now, I'm not sure if you really want to attend a cross-examination using a phone, but
that's another issue, because people want everything to be so easy and accessible that it becomes almost unreasonable. We must not forget this is still a legal process. This is still serious stuff. So I don't want to do stuff on a tiny screen and make big decisions without being able to read properly. Yeah. So the app sounds very cute, maybe for alerts or like go back home, sit on your computer and log in. But I kind of agree with you.
Yeah. So we have the mobile version, at least, like as in terms of like a mobile browser version. So you can still on the go look at your case information. If you need the financial aspect, you can quickly look at that. You can do that all through your phone. It's just that we haven't had like an app yet, and whether we're developing that I need to keep that secret for now.
I was just curious because everybody's on their phones, but I agree with you. Look, I already see a massive progress how ODR is becoming, apart from the beautiful integration of different technologies and a very reasonable and balanced use of AI for transcription and translation. But I think, and of course, the interfaces, the look of it is getting better. It's user-friendly, as I said. But I think that there should be a limit as to how cute and easy it should be, because people tend to forget this is not a game or shopping. This is still serious stuff.